The following is a station editorial.
This is Holland Redfield. Arriving at an acceptable and all-inclusive constitution has again eluded the people of the Virgin Islands after decades of failures and divisiveness, which has now led the governor of the Virgin Islands to the conclusion that the process and this document again has failed. The debate now is, did the governor have the authority to hold the document and not pass it along to the President and the Congress of the United States? The enabling legislation which created the Fifth Constitutional Convention was very specific on this point, and case law supports the governor's position that he himself cannot be party to forwarding a document which he knows is legally deficient. And we believe that the courts will come to that same conclusion. He was both morally and legally within his executive powers to have stopped this process, and he did not blink when it came to making this politically charged decision. Here enters the president of the Fifth Constitutional Convention, who has challenged the governor's position in the U.S. District Court by filing a writ of mandamus, attempting to compel the governor to move the document forward. The first question to ask, does the Constitutional Convention have legal standing? That would need to be determined by the courts before any larger issues can be considered. The governor had to look for the legal authority which the constitutional delegates had, which clearly set forth the sovereignty of the United States had to be recognized in the draft of the Constitution, and clearly the sovereignty clause was omitted. When one looks at the preamble of the Constitution as drafted, it clearly states it will not discriminate, but then contradicts that position within the body of the document. After analyzing the document, the chief executive and the attorney general of the Virgin Islands would have had to conclude that they had no choice but not to move the document forward because it is at odds with the equal protection provision of the 14th Amendment of the United States Constitution. For example, the Constitution as drafted abridges the rights of any resident to run for governor or lieutenant governor and ties that right to a narrow definition of who is a native and or an ancestral Virgin Islander. It also proposes a new special class of ancestral Virgin Islander who would be exempt from paying property taxes. The administration would have had to look at how the delegates proposed to reconstitute the legislative branch of government, in which St. John would have an overrepresentation and St. Croix and St. Thomas underrepresented under the one-man, one-vote rule. Now the big question, where do we go from here after the dust settles? We firmly believe in self-determination and that we need a constitution. We also believe, because of the contentiousness of this process, that a cooling-off period would be appropriate. It is our hope that the legislative and executive branches of government will move forward and not retreat. After all, we are capable of writing our own Constitution.
Please email your comments to our editorial department. Our email address is editorial@viradio.com. Please include your name and other contact information.